We will be expanding upon it. Every other month we will do a webinar in estate planning, and in the alternate month would be one on asset protection. So we're starting a series, we're starting with the basics, and we'll be moving forward into more detailed planning. And if you have any ideas on any webinars, things you'd like to hear about, feel free to let us know and we'll try to incorporate that into the future webinars. A little bit about myself. I've been an attorney for 25 years. My practice is mostly in South Florida. I do estate planning and asset protection. In addition to that, I am an adjunct professor at Florida Atlantic University, where I teach wills, trusts, and estates to the paralegal students. The basics in estate planning are all about documentation. We start with documents on incapacity planning, because incapacity planning is for people who are still living, but who are not necessarily able to handle their own financial and medical matters for them. So we start with documents for that. The documents we're going to go into in just a moment, but that's what I like to call incapacity planning. When you continue from incapacity planning, you move into wills and trusts. Wills are documents that tell us what's going to happen to our assets upon our demise, and trusts can either be done as part of a will or separate from a will, and they are a different means to pass our assets at our death, and we can use them during life as a gifting strategy. We can use them for tax planning. There's a lot of different things that can be accomplished with trusts, and we'll touch upon some of those things today. Starting with the incapacity planning, there are really 4 main documents that we use to cover incapacity. That doesn't mean there aren't other things that we can do and that we do incorporate, but these are the 4 main documents that I'd like to speak about today. The first one is called a durable power of attorney. And what that document is a way for one person to engage another, we call that person the agent or attorney in fact, to be able to handle financial matters for us in the event that we are unable to do so ourselves, or in the event that we cannot, whether it's because we are physically, mentally incapacitated, or if we're just unavailable. So the power of attorney is generally a fairly broad document that gives power to another person to sign things on your behalf, to open bank accounts and manage them, to sign business documents, insurance paperwork. It could really be almost anything. I've seen powers of attorney that are 1 page long, and I've seen them that are 30 pages long. A lot of it depends on who's drafting it and what the purposes are. And there's also a factor of what state you live in, because that's where you have to have your power of attorney. And different states have different rules, but the majority of them are somewhere between, let's say, 4 and 7 pages long. They generally enumerate many different powers that an agent would have. And what I've been seeing a lot lately, and especially in Florida, is where you have certain powers that are generally very significant powers that are subject to a potential abuse by the agent, that those are singled out so that when the person who creates the document is signing it, they have an opportunity to specifically look at these different provisions and say whether or not they want them to apply and whether or not those powers should go to the agent. And those would usually be singled out and initialed. So for instance, if you were in Florida, one of the things that we like to cover as a singled out power is whether or not an agent on behalf of, we call it the principal, is able to change beneficiary designations. So if the principal has an insurance policy and names someone as a beneficiary, does the agent have the right and power to change the beneficiary? It's a fairly significant ability to be able to do that. So we like to point that out when we have our clients sit down and do a power of attorney, we like to single that out and ask the client directly, because the rest of the document is pretty comprehensive. It's very broad. So that's one of the things we like to single out. Another thing we might single out is, can the agent create a trust for you? And what that means is, let's say you have not done all of your estate planning. Can your agent go ahead and create a trust? Generally, it's a revocable trust, but it's for the benefit of you during your lifetime. Normally, you would have created it, but if you didn't create it, do you want your agent to be able to do so? In most cases, you'd probably say no, because you've probably already done your trust. But if you haven't done your trust, then it is definitely something that we discuss with the client when they're sitting down at the table and signing their documents. The potential for problems there is less than you would imagine, because if the document says, the power of attorney will say that the agent can create the trust for the benefit of the principal. So you should be well protected by that. The question is, does the agent have the ability to determine who would get your assets upon your death? And that's where you have a little bit of a problem, and you need to discuss with your agent whether or not they should have that power. The other things with the power of attorney are, is it a durable power of attorney or is it a non-durable power of attorney? Most of you have probably heard the term durable power of attorney. All that means is that there is a clause inside the power of attorney that says, in the event that the principal, the person who's creating the power of attorney, becomes incapacitated, the power of attorney will still be in effect, which means you create the power while you're all well, and then should you become incapacitated, the power of attorney is still viable and the agent can act on your behalf. What you're probably saying is that that makes total sense. I wouldn't want the power of attorney to be in effect beforehand. I'd only want it in effect if I would become incapacitated. And while that's a fairly logical thought, some states, including Florida, don't look at it that way. We changed our law back about 7-8 years ago and said that a power of attorney is in effect the moment you sign it. If it's durable, it continues to be in effect despite your incapacity. So you have to be extremely careful who you appoint in that power of attorney, because you are essentially, without any other way to say it, giving them a license to steal. You're giving them the abilities to act on your behalf today. The way we recommend is whoever you name, you can tell that person that you've created some estate planning documents. You don't necessarily have to tell them exactly what those documents are, but you tell them where you might keep them in the event of an emergency. And then we say, do not give out any copies of the power of attorney to anyone, because once you give it out, it's essentially out there, and if that person chooses to use it, then there is a potential for abuse. So it is a very important document to have, because it does give somebody the ability to sign for you if you can't do it or if you're unavailable. It is a good protection against your future incapacity, but there is definitely a danger to it, so you have to be fairly sure and fairly trusting of who you're naming in that document. The next document we do for incapacity is the healthcare surrogate. It's called healthcare proxy, durable power of attorney for healthcare, a lot of different names it goes by. But the bottom line is it all accomplishes the same thing. If you can't make medical decisions for yourself, name somebody to make them for you. When I sit down with a client and talk to them about who should be the people that they choose for these different roles, I tell them that with a healthcare surrogate, you want to choose the person who's going to be able to make the best informed decisions, which means if you have some choices, you don't want to choose the person who's highly emotional, who's just not going to be able to make decisions when situations are serious. You want to choose somebody who can listen to the doctors and can assimilate the information and make an informed decision that they think you would have made yourself. So it's a very important document to have. I also don't recommend naming multiple people to serve together. It becomes a little bit cumbersome when you've got too many people who are trying to make decisions. You're better off just choosing one person. You can choose as many alternates as you want in case somebody is unavailable or isn't willing to serve or has passed away. But it's probably more practical to always choose one person for these types of designations. The pre-need nomination of guardian is a document that basically tells the court, in the event that you were ever brought before a court to be declared incompetent, who you would like to be as your guardian. And a guardian can either be in charge of you personally, just like physical custody of a child. They're in charge of, where you live, your health care, that you get to the doctor, that you've got clothes and food and your daily needs. And there's a guardian for money. That would be a guardian of the property. It's generally the same person. It does not have to be in most jurisdictions. On a practical level, it should be the same person, but there are times where it makes more sense to you that the person who's in charge of your money is not the person that you would want dealing with your daily care. So you do have options. You can name two separate people for the two different roles, but as a practical matter, if you can find one person who could do them both, it would probably be more time efficient, more cost efficient, and more practical. The next document that we use for incapacity is a living will. The living will is the document that tells whoever is in charge of your medical care and alerts the doctors and medical staff that you do not want life-prolonging measures taken to keep you alive if you're going to have no quality of life. The only time the living will ever kicks in is if you are no longer able to communicate and make your own decisions, and the medical staff has determined that your chance of survival and your chance of any quality of life is infinitesimal. A lot of people have said to me, well, wait a minute, what if I want a chance? I don't want them to just jump the gun. Well, you can put stuff in your living will and put provisions in there that put some parameters. The only thing you want to notate is that once you allow certain machinery to be put on you, it's not so easy to detach it. Meaning, sure, it's easy physically, but it's not so easy from an emotional sense, and you may get some pushback from the medical personnel. So you have to think things through, and that's why it's so essential to name the right person as your healthcare surrogate, because ultimately it's going to fall on that person to make those decisions. Now, there are certain religion considerations to be looked at if you're doing a living will. So certainly speak with your estate planning attorney and mention if you are devout in any religion, because there are rules that you may or may not want to follow. Another thing that we do as part of incapacity planning sometimes is if we want to make sure that if something happens to an owner of a piece of property or of a bank account, that it's easy for the other owner to be able to handle things, we could consider creating what's called a joint tenants with rights of survivorship ownership. What that does is it says two or more people can own some sort of piece of property, whether it's real estate or personal property, and in the event that one of those people should pass, the others immediately survive to the ownership and just get a bigger percentage. It's good for a bank account in the sense that if you become incapacitated, the other owner has full rights to be able to withdraw any money and write checks and do whatever's necessary to deal with any of your care, any of your bills, or anything like that. And it's easy because if you pass, it'll avoid probate. We're not going to really go much into asset protection today, but I can tell you it's not definitely a good type of ownership for asset protection. It has its place in estate planning, but it's not great for asset protection. The next stage is, unfortunately, when you pass, what's going to happen to your assets when you pass? Do you have a will or do you not have a will? I get asked the question all the time. Well, if I have a will, I avoid probate, don't I? And the answer is no, that's not what happens. When you pass away, if you own any assets in your individual name that have no living beneficiary designated or are not owned with any sort of survivorship right, then that asset needs to go through the court in order to be transferred to the next person to inherit it. The difference between having a will and not having a will is that if you do have a will, then your will is going to dictate where the money goes, who's going to be in charge, who's going to be guardian of your minor children. It's still going to go through the court process. If you don't have a will, it's called dying intestate, and what happens is that you're still in the court process. It's the same process, give or take different forms, but we're going to have to look to the state statute to determine who inherits your assets. So let me give you some examples. If you were in Florida and you died a single person and you'd been in a long-term relationship and you had wanted your assets to go to your long-term partner, if you die without a will, the partner gets nothing. Everything would go to your children if you have, and if not to children or grandchildren, then it would go up to your parents. And then it goes out to your siblings. There's a whole hierarchy of who inherits. But your partner would get nothing because under the laws of intestacy, they are not a qualified heir. If in the alternative you had created a will, your will could leave any assets that you want to your partner, and they would inherit through the same process, through the probate process in the court, but they can inherit your assets. So the difference is, look at the statute versus look at the person's individual desires as to where they want their assets to go. And the will is just a document. It could be a very simple document. It could be a complicated document. There's a lot of different options that you could do. You just need to make sure that you do one, because otherwise you're stuck with whatever the state statute says, which may be fine with you, but you really want to know what the answer is if and make an educated decision not to do a will. And I can tell you, I've had people come to my office and we've sat down and I've educated them on what would happen if they would die without a will. And at the end, we determined that it really wasn't necessary if they didn't want to go through the expense to make a will. The will gives away your assets, and you can have that very simple in terms of, I give my watch to my son, or I can make it more complicated and say, I leave my assets in trust for my children or my grandchildren or my spouse, and it could be a very long trust with lots of different provisions in it, or it could be a very simple trust that just says, I leave assets in trust to my children or grandchildren until they're age 21. Until they're age 21, the trustee can pay for health education, maintenance, and support, and at age 21, they get everything that's in the trust. That's called a simple trust for minors. Depending on what state you live in is how complicated your will might be. For example, if you were living in New York or New Jersey, where my understanding is their probate system is really not that difficult and painful, you're going to see a will that's usually extremely lengthy, but you're going to see people of all means with many millions and billions of dollars doing wills with trusts inside the will rather than doing what we're going to talk about next, which is a revocable trust. So it's going to really depend very much upon the probate process in your state. In Florida, I've met people with almost no money who have trusts because here the probate process is really not great. It takes a long time, it's expensive, so people lean towards revocable trusts here. And again, I've seen it for people who have very small means, and I've seen it for people who have, much more. But it's mostly based on the fact that the probate process is not really great here. The other thing that a will does is it gives you the opportunity to name the guardians for your minor children. And just like we talked about for guardians for you as an adult for incapacity, you can name separate guardians for the person or physical custody and daily needs of your children, and someone who can handle the money, guardian of the property. Again, it's not practical or very practical to name two different people, but these are your children. If you feel there's somebody who would really be an amazing person to raise your children, but you really don't want to have them in charge of money, then you separate out the roles. You do what's best for the children. If you can be lucky enough to find somebody who can handle both elements, then you're in great shape. I find, interestingly enough, that the people that don't go and do their wills don't do them for the same reason that the clients come and say they need to do a will. And it usually comes down to guardians for minors. I find that a lot of people have very difficult time coming up with who is going to be the right guardian for their children. And a lot of times I find that couples don't agree on it. So instead of fighting it out and making a determination, a lot of times they just don't do anything. And I've had many clients come in their 50s, 60s, 70s who've raised their children. They're long into being grandparents, and they said they never had a will. And the reason is that they just didn't want to deal with appointing guardians for their children. And again, it's the same reason that people do come to me and say we must have a will because we need to appoint guardians for our children. So it's just very interesting, and I see that all the time. But appointing those guardians for the children is very important, because the last thing you want is, God forbid, something happens to you when the children are young and there's no consensus in the families as to who should take the children. Then there could be potential fights, a lot of bad feelings from the different families, and in the end, it's only going to affect the children. In Florida, we have a rule that says that you can only appoint a guardian who is a member of your family or a resident of Florida. So if it's a family member, they could live wherever, but if you're going to appoint a friend, they have to be a Florida resident. So it's very important to know the different rules as to who is allowed to be appointed as a guardian. I've actually had people who've come in here with existing documents, and it doesn't say that. And when they learn that, they realize that they didn't get the greatest advice. So always know the rules of your state to know who is a permissible guardian. We also use trust as part of estate planning. And first, what I'd like to do is demystify a myth or a misconception regarding revocable and irrevocable trusts. The definition of a revocable trust is a trust that you create which is able to be terminated, amended, changed, revoked, whatever you want to do with it. The person who creates that trust, who we call the grantor or the settlor, is able to do whatever they want with the trust because they are usually the beneficiary and the trustee. That is not any tool that can be used for creditor protection. It can't be used for tax planning during your life, although it can be structured with some tax planning after your death. It's revocable. It's simply a way of avoiding probate, putting in provisions that let money stay in trust after you're gone. And it helps if you become incapacitated because you've got everything in a trust, and therefore your successor trustee can take over and do anything that they need to do in order to handle your assets for you. The irrevocable trust is one that's created and essentially cannot be changed. There are different ways that an irrevocable trust can be changed. Beyond the scope of today's conversation, we will probably be having a webinar at some point on irrevocable trusts, and I'll go into that in more depth. But there are tools that can be used. But the essential element there is whoever creates it is giving up rights to the money, giving up the right to change anything, and for that reason, it's good for creditor protection, and it can be used as a tax planning tool. But if you're going to use it, you need to understand that you're going to have severe limitations on those assets, and you are giving them up. So they are used for estate planning, but they're used for very specific purposes. We use them for tax planning, we use them for life insurance, very specific. The revocable trust is really the main tool for just basic estate planning. When you do a revocable trust, you still need a will. It's just called a pour-over will. It's a special type of will that just says, if I do own anything in my individual name when I die, meaning I didn't fund that trust completely while I was alive, then I want all those assets from my individual name. I know I have to probate it, but put them in the trust. The reason we do that is because ultimately we've put all this work into the trust, all the provisions of the trust. Where do we want things to go? When do we want them to go to our beneficiaries? Under what terms? At what ages? When should the trustee hold them back? Who should have discretion? All those things, all that is put into the trust. So we ultimately want all of our assets, to the extent possible, to go through that trust. A trust can own anything. It can own real estate. It can own bank accounts. It can own stocks. It can own interest in companies, whether it's a corporation or an LLC or a partnership. All those things can be owned in trust. So if you do have a revocable trust, your goal should be, to the extent possible, to hook everything up through that trust, because that is where you're going to determine who gets what and how. I've mentioned a little bit about probate, and probably not too positively. But probate is essentially a process that the court uses, and every state and every country has some sort of process by which assets must change title from a deceased person into the heirs or beneficiaries. In order for this to happen, you have to follow the court's protocol. There's paperwork to be filed. There's disclosures to be made in terms of an inventory of all probate assets. There's beneficiaries and creditors to be notified. There's potentially creditors to be paid. There might be lawsuits for people who decide to contest the estate, and all that gets done with the court. Depending on the court, in every state and every county is going to be different. I can tell you there's a huge difference between, in Florida, where I am in South Florida, Miami-Dade County versus Palm Beach County. Huge difference. So that process could take longer or shorter depending on where you are. It could take longer or shorter depending on what judge you get. There's so many different factors that go into an estate. So even when you think you have something super simple where it's very clear, it's just two adult children inheriting, there's a bank account, and that's it, that doesn't mean that that estate is not going to take a minimum of 4 months, and that's if you're very lucky. A judge may require as a personal representative, also known as an executor, to put up a bond in order to serve in that role. You'd think that would be easy. That's not so easy either. There's a process that has to be followed in order to get that done. And since you probably don't know it in advance, it's a delay in processing. So just because somebody passed away a week or two ago doesn't mean their estate is going to be opened up at any point in the next few weeks. There is a process, and again, every place you have to go, whether it's whatever your state is, whatever your county is, you have to follow their particular process, and you have to follow the particular judge's process because different judges can have different rules. And that is why in Florida we like to avoid probate, because there's just so many things that can make delays in getting anything distributed. And all you hear is from the beneficiaries asking when can they get their money, and we just have to give them the bad news. They have to wait. We can't do anything. Or they can get some money, but we can't give them all the money. Or we have to wait for the creditor period to expire. It's a necessary evil in order to transfer property from a deceased into another name, but it's not an easy process to go through in many places. So that is why, at least here, revocable trusts are very in vogue, because it just makes life a lot easier. The creditors will always have their option at a person's death to go forward and try to file a claim. If there's a probate opened, then there's a means for them to get paid because they can file the claim, and before the estate is distributed, their claims have to be dealt with, whether they're paid in full, whether they're negotiated, whether the claim is objected to, they're dealt with. If you have a revocable trust and you do not go through probate, the creditors still have 2 years from your death to come forward and put a claim in against your revocable trust. The difference is, with a probate, you have to notify the creditors that you know about. With no probate, you don't really have to notify the creditors, but you have to kind of sit like a sitting duck for 2 years to see if the creditors are going to figure out that the person has passed away and come after them. So it's a personal decision as to how to handle it. I've seen people who have revocable trusts file an empty probate just to dispense with creditors so that they can move on without having to worry about a creditor coming back. You rarely see a creditor go after a revocable trust, but they do have the option if they so choose. So when should I have my estate plan reviewed? Any life change, whether you get married, you get divorced, you have a new child, you become a grandparent, you move to another state, you have an illness, your finances change. Any one of those events should trigger your going to your estate planning attorney, or if you've just moved, go to an estate planning attorney in the new state and have them review your documents. You may not need to make any changes, but you want to stay on top of it. If you don't have any life-changing event, it's always nice to look at it every year, but I know that's not usually a very feasible option. So check in with your estate planning attorney every once in a while and see if there's any new laws that affect you. For instance, back in 2010, that's when our power of attorney rule changed that said that the power of attorney is effective immediately and you cannot have it just kick in the event of your incapacity. That was an important change, and people needed to make some changes to their powers of attorney. When the estate tax laws changed, which they just changed quite significantly, it's important to revisit your estate planning and see if anything needs to be changed. So I like, as a general rule, let's touch base every year, see what's going on. If there's nothing new, then we probably don't have to change anything. But it's always nice to take a look at it. There's always enhancements that we make in our documents, so you never know, maybe you could benefit from, the attorney's newer documents. But I like to say every year is nice, at least every 3 years if you can do it. However, a good estate plan should cover most new events. It should cover if you have an additional child, if your child has children and now you have grandchildren, if you get divorced, if you get married. Those are a little bit more difficult to plan for in advance, but even those I've planned for in advance with single people, because I know how long it takes somebody to walk into my office to do an estate plan. I'd be leery of them actually coming back to make changes. So I always make sure to at least try to plan for as many events as possible. Obviously, I can't plan for everything, but a good estate plan is going to do its best to plan for these things so that you don't have to jump in the minute you have another child, run to your lawyer to see what needs to be changed. That's the scope of today's webinar. Every other month, we're going to do an estate planning webinar. In June, we're going to have a webinar on an asset protection topic, which we will be sending out in our newsletter. We're going to put on hold for a couple of minutes now, see about any questions that have come in, so please bear with me. Okay, we've had some questions come in. The first question is, does my will get filed anywhere? And I get asked this question a lot. Your will is your private document. Until you pass, your will has absolutely no merit. It is not viable until the day you pass away, which means you can change it and tear it up and do whatever you want with it. So in most jurisdictions, you don't put that will anywhere until after the person passes away. The only time you would consider registering it and depositing it with the court where it would ultimately be probated is if you were afraid that your beneficiaries wouldn't follow through on it and that there was potentially going to be some sort of will contest. Then you could consider depositing it with the court. And then it would be there, and if you decided to change your will, then you're going to have to go and get that from the court, and it could be a process. So my feeling is always leave it in a very secure place. Don't give anyone a copy of it, because if you do decide to change it, it's nobody's business what it used to say. Next thing we were asked about is, what if you move to another jurisdiction? If you move to another state, do you have to change your documents? The general rule is you probably have to make some changes. You may not have to change everything. It's very important to have them looked at by a local estate planning attorney and then follow through on whatever suggestions are made. There are different laws in different states, so they may not all be the same. You also always have to look at and have the attorney review how was the document signed. Every state has different rules about how many witnesses, whether or not there should be a notary, how many times you and the witnesses have to sign. I've got caught in the pickle between New York and Florida several times, where New York's requirements are the testator signs the will, the witnesses sign the will, then the notary signs the will. In Florida, we have a different process, and in Florida, the testator and the witnesses sign twice, and then the notary signs. So while the will was still valid, the New York will was still valid, we had to go through extra steps that you wouldn't have had to go through if a Florida attorney had reviewed the will and said, no, we need to do a little bit extra here. So you always want to revisit them and maybe, look at whatever changes need to be done. Another question we were asked about is probate. The probate process is one of those things that I consider a necessary evil. It starts with hiring an attorney to get an estate opened. And once you get an estate opened, which is a process of filing papers, determining who the beneficiaries are, what are their addresses, is there a valid will, is there not a valid will, filing it with the court. Then once somebody is appointed to take care of the probate, to be the personal representative or executor, that person then has to inventory the assets. They have to notify the creditors. They have to publish notice in the newspaper to potential creditors that they don't know about. They have to negotiate any debt. They have to pay any viable bills. They have to communicate with the beneficiaries, sometimes not very pleasantly. They have to manage any of the assets that are sustainable assets. For instance, if there's real estate, they have to make sure that the properties are being cared for. Maybe they're being rented out. Maybe they're empty. You have to clean them out. There is so much that goes into the job of a personal representative that I actually laugh sometimes when my clients come in and they tell me, oh, I don't know who to name because I don't want this one to be insulted. And my thoughts are, it's really the worst job on the planet. I don't know why anybody would want it. But on the other hand, I have definitely seen where one child is insulted that they weren't named as the personal representative. It's a very big job. It's very time consuming. The good news is in most jurisdictions, you are entitled to a fee. The bad news is if everybody who's a beneficiary is your sibling, you're less likely to take the fee because they're going to complain. So usually it's just a thankless task, but it's necessary. There's no other way to move assets from an individual's name into whoever is going to be inheriting it. I'm going to have another webinar on more details on probate sometime in the next few months, because I know there was a question on that. I want to thank everybody for joining us today. And if you would like to participate in future webinars, as I said, we do them every month. Stay tuned in our newsletter for any future topics. And if you have one you'd really like us to discuss, please just email us and let us know. And I'm the one who puts them together. I'd be happy to put one together for you. Well, not for you, but for everybody, but with you in mind. So thank you very much for joining us today, and have a great day.